Your brother needed the capital more than you do, my father said, refilling his coffee like he'd just commented on the weather. We restructured the joint account. Think of it as an early family investment. I was 31 years old, sitting at my parents' kitchen table in their Naperville ranch house, and I had just watched my retirement savings disappear in a single sentence. The joint account my father was referring to wasn't a family fund. It was the account my grandmother, his mother, had set up for me alone when I graduated college. $48,000 she had saved over 20 years of clipping coupons and skipping vacations. She called it my serious money, the kind you don't touch until it matters. I had added to it carefully over 9 years of working as a licensed home appraiser, watching it grow to just over $90,000. Enough finally to put down on my own appraisal firm. Enough to stop working under a franchise that took 30% of every contract I brought in. My brother Colton had a landscaping business that had been almost profitable for 6 consecutive years. I looked at my mother. She was straightening the ceramic rooster on the counter. She wouldn't meet my eyes. That account has my name on it, I said. Only my name. Your father has co-signatory rights, sweetheart. Colton needed equipment financing and the bank wouldn't extend him another line of credit. We had to think about what was best for the whole family. I stared at her. Colton was 35. He had borrowed money from my parents 4 times that I knew of. None of it had come back. He owned a boat. How much? I asked. My father set his mug down. $60,000. The room tilted slightly. I gripped the edge of the table. You took $60,000 out of my account without asking me. We didn't need to ask. The co-signatory structure. Grandma set that up so you could help me manage the account if something happened to me, not so you could drain it for him. My father's jaw tightened. He had a very particular look he used when he felt his authority was being questioned by someone who should know better. I had been seeing that look my entire life. Colton is trying to build something, he said. You have a steady income. You have your license, your contracts. You don't need $90,000 sitting in a savings account when your brother is struggling. We raised you to think about more than yourself. From the living room, I could hear the TV. Colton was in there. He had been in there the entire time. I wondered if he had known about this before I arrived. If the easy way he'd said, "Hey sis," when I walked in the door had been its own kind of performance. I want it back, I said. All of it. I'll give you until the end of the month. My mother finally turned around. Her voice dropped into that low register she reserved for moments when she wanted to sound reasonable while saying something monstrous. You know what happens to this family if you make this ugly. Your brother's business folds. He loses the house. The kids lose their school. Is that what you want? To be the reason this family falls apart over money you weren't even using? I wasn't using it because I was saving it. No one spoke. I walked to the living room doorway. Colton was on the couch, watching a home renovation show, not looking at me. Did you know? I asked him. He reached for his soda. Look, Brooke, it wasn't my idea. But you took it. He shrugged. One shoulder barely, Dad offered. I needed the equipment. It's not like you were hurting. I left without saying goodbye. I drove 40 minutes back to my apartment in Evanston with my hands tied on the wheel and my eyes burning, and I made myself a promise in the parking garage before I went inside. I was going to get every cent back, and I was not going to apologize for it. I called a family law attorney the next morning. I explained the account structure, the co-signatory clause, the withdrawal. She listened carefully. Then she told me something that made my stomach drop. The co-signatory clause your grandmother established gives your father the legal right to transact on the account, she said. In Illinois, challenging this will be an uphill battle, without evidence that the funds were designated for your sole benefit. But they were. She told me that. Verbally? Always verbally. Any written documentation? Anything in the will? My grandmother had died 2 years earlier. Her will had been modest, dividing her small estate equally between her 3 adult children. The savings account had been established separately, outside the will, in both my name and my father's, for convenience, as she'd always said. The attorney laid it out plainly. Without documentation of intent, my father's withdrawal was technically authorized under the account terms. I could file a civil claim, but without strong evidence of fraud or undue influence, it would likely be dismissed. So they can just take it, I said. The attorney was quiet for a moment. Not forever, she said. If there's anything in writing, letters, emails, account notes, anything that establishes your grandmother's exclusive intent, that changes the picture significantly. I thanked her and hung up. Then I sat in my car in the parking lot outside her office and tried to think about everything my grandmother had ever written down. She had been meticulous, old-fashioned in the best way. She wrote letters by hand and kept carbon copies. She wrote notes in the margins of her checkbooks. She kept a small leather journal for what she called important decisions, things she didn't want to forget, things she wanted to explain to someone eventually. I hadn't touched her personal effects since helping my aunt box them up after the funeral. They were in storage at my aunt's house in Rockford. I drove to Rockford that Saturday. My aunt didn't ask many questions. She knew things had been tense since the funeral, though she didn't know about the account yet. She took me to the storage unit, unlocked it, and left me alone. It took 3 hours, but I found the journal at the bottom of a box labeled Financial Records, tucked between 2 years of tax returns. I opened it carefully, the binding stiff with age. My grandmother's handwriting was small and looped and entirely her. I turned pages slowly, reading entries about decisions she had made, loans she had given, money she had moved. And then I found it. An entry dated 11 years ago when she first established the savings account. She had written the name of the bank, the account number, and then, in her careful script, "This account is for Brooke alone. Harold's name is on it only because Brooke is young and I want someone to call if anything happens to her. Harold is not to use these funds for himself or for anyone else. This is not family money. This is Brooke's future. I am writing this down so there is no confusion later." There was no confusion later. There was just my father, who had read his mother's intentions and decided they applied to everyone except him. I photographed every page of that entry with my phone. I sent it to the attorney that night. She called me Sunday morning. "This is significant," she said, and I could hear a shift in her voice. "This establishes clear donative intent. Your father's withdrawal may now constitute conversion of funds. Civil theft, essentially. We can file." I told her to file. My father called me 3 days later. His tone was different from the kitchen conversation, tighter. He had heard from his attorney. "This is a mistake, Brooke," he said. "You're going to embarrass this family over a legal technicality." "It's not a technicality," I said. She wrote down exactly what she meant. "You knew." He was quiet for a moment. "Then, you want to drag your grandmother's name through a courthouse? Use her private writings to sue your own father? She would be ashamed of you." "She wrote it down because she knew someone might do exactly this," I said. "She wasn't naive." He hung up. What followed was something I hadn't expected, even after everything. I had thought he would negotiate, maybe offer to return some portion of the money in exchange for dropping the case. I had thought my mother would call and try to smooth things over. I had thought Colton might actually feel guilty enough to do something, say something. Instead, they went to war. Within a week, I received a certified letter from my parents' attorney. They weren't just contesting the civil claim. They were countersuing for intentional infliction of emotional distress. Attached to the letter was a declaration signed by Colton stating that I had, over the course of several years, systematically manipulated my grandmother against the rest of the family, isolating her to gain preferential treatment. I read that sentence 4 times. I had visited my grandmother every Sunday for the last 8 years of her life. I had driven her to chemotherapy appointments when she was sick. I had held her hand in the hospital the week she died. And now my brother was signing his name to a document saying I had done it to steal from them. The next blow came from a direction I didn't see. My employer, the appraisal franchise I had worked under for 7 years, called me in for a meeting. My manager, a man I had genuinely respected, sat across from me with a manila folder in front of him. "We've received some concerns," he said, "about your professional judgment." "What concerns?" He slid the folder across. Inside were 3 client complaint letters, all dated within the past month, all claiming that I had provided inflated appraisals to clients who were referred by a specific mortgage broker. The letters claimed I had accepted kickbacks in exchange for favorable numbers. I had never met the mortgage broker named in the letters. I had never accepted anything from anyone that wasn't on my fee schedule. "These are fabricated," I said. He looked genuinely uncomfortable. Brooke, your father called the regional director. He said you've been under significant psychological stress and that your professional judgment may be compromised. He expressed concern. My father called the regional director. He said he was worried about you. I looked at my manager and thought about everything I had built in that office. 7 years of contracts, of referrals, of a reputation that I had earned by being precise and honest in an industry where both were scarce. I'm not resigning, I said. I know, and I don't want you to, but we need to place you on a temporary internal review pending investigation of the complaints, standard protocol. I went home that afternoon and understood, fully, what I was dealing with. My father wasn't trying to settle a dispute, he was trying to make it easier to claim I was unstable. He was trying to compromise my income and my credibility before the civil case could go anywhere. I went back to the attorney, I told her everything. She connected me with a colleague who handled professional defamation cases. Between the two of them, they started building a second case alongside the first. But the following week brought something I hadn't anticipated. A process server appeared at my door at 7 in the morning. The envelope contained a motion to compel arbitration, filed by my parents' attorney, citing an obscure clause in my grandmother's original account set of documents that they claimed required all disputes over the account to go through private arbitration rather than civil court. I called my attorney in a panic. She reviewed it by noon and called me back. They're trying to move this out of public court, she said, because public court creates a record. Arbitration is private, and the arbitrator pool skews heavily toward financial institutions. This is a delay tactic, but it's a legitimate one. We'll contest it, but it may take 60 to 90 days. 60 to 90 days. I had enough in my checking account to cover 3 months of rent, maybe 4 if I was careful. My internal review meant reduced hours and reduced pay. The legal fees were already climbing. I sat in my apartment that night eating cereal for dinner, looking at the journal entry photograph on my phone, and I made myself go through everything one more time from the beginning. My grandmother had been careful. She had written things down. If she had written in the journal, what else had she written? I called my aunt the next morning and asked if there were any other papers, letters, correspondence, anything with the bank or the account specifically. She was quiet for a moment. Then she said, she used to write to the bank. When she set something up, she always sent a letter to confirm. She said she didn't trust phone calls. I drove to Rockford again. In a different box, labeled simply Sick Correspondence, there were dozens of letters filed in order by year. Near the bottom, in a manila envelope marked with the bank's name and the year she opened the account, I found a letter she had mailed to the bank branch manager when the account was established. She had kept a copy, as she always did. It was 2 paragraphs. The first described the account she was opening and the amount she was depositing. The second paragraph read, I want to note for your records that this account is intended solely for my granddaughter, Brooke Hendricks. The secondary signatory, my son Harold, has been added for emergency purposes only and has no beneficial interest in the funds. Please note this in your account records. I stood in that storage unit for a long time without moving. She had sent this to the bank, which meant the bank might have it in their records, which meant there was a paper trail that existed entirely outside my father's reach, filed 11 years ago by a 72-year-old woman who had understood exactly what she was doing and exactly who might try to undo it. My attorney nearly dropped the phone when I read it to her. If the bank retained that correspondence, she said, this isn't just evidence of intent. This is a formal notice to the financial institution establishing your father's limitations as signatory. Depending on how the records team logged it, your father's withdrawal could constitute fraudulent misrepresentation to the bank. That's not civil. That's potentially criminal. It took 2 weeks to subpoena the bank records. They had it. Scanned into their system, still attached to the original account file, never removed. The motion to compel arbitration was denied. The judge cited the newly submitted evidence as material to the question of fraud, which fell outside the arbitration clause's scope. We were staying in civil court, and the county DA's office had been quietly notified. My father called me the night before the first court hearing. I almost didn't answer. When I did, there was a long silence before he spoke. We can work this out, he said. Outside of court, we'll return the money. All of it, I said. All of it, and we'll withdraw the counterclaims. What about my job? He cleared his throat. I'll contact the regional director and clarify that my earlier call was made out of personal concern and doesn't reflect any professional knowledge of wrongdoing. I need that in writing, I said. Notarized. Another silence. Then, fine. And Colton withdraws his declaration. Brooke. All of it, or I see you in court tomorrow. He agreed. I wish I could say the call felt like victory. It felt more like exhaustion with a thin silver lining. I had spent 4 months fighting for money that had always been mine, using evidence that my grandmother had put in place before I was old enough to understand why she might need to. She had known. She had loved her son and she had known anyway, and she had protected me the best way she knew how. Quietly, in writing, filed where she thought it might be found. The money came back in full within 2 weeks of the settlement agreement. My professional review was closed. The internal investigation found no evidence to support the complaint letters, which had been submitted without corroborating documentation, and which the franchise's legal team subsequently flagged as potentially actionable defamation. My attorney is currently finalizing that filing. Colton called me once, a few weeks after everything settled. He didn't apologize exactly. He said things had gotten out of hand and that he had been put in a difficult position. I told him I understood and that I wished him well. I meant the first part. I'm still working on the second. My parents have not called. I signed the lease on my own appraisal firm's office space last month. It's a small suite on the second floor of a building in downtown Evanston, with a window that faces east. The name on the door reads, Hendricks Valuation Group. I chose my grandmother's maiden name for it, because it was her money that made it possible, and because I wanted something of hers to be there with me every morning when I unlocked the door. She used to say that careful people leave a record, because the world doesn't always reward honesty in the moment, but it almost always rewards the paperwork. She was right, she usually was. I keep a photograph of my grandmother's handwriting on my phone, not because I need it anymore. The case is closed, the money is back, the office has my name on the door, but because I look at it sometimes when I'm tired and I need to remember what actually saved me. It wasn't the attorney, it wasn't the subpoena, or the judge's ruling, or any of the things that happened in the final weeks. What saved me was a woman who sat down 11 years ago with a pen and a piece of paper and decided that love, real love, means thinking ahead. It means doing the quiet, unglamorous work of protecting someone before they even know they need protecting. My grandmother never said anything dramatic about what she'd done. She just filed the letter and closed the envelope and moved on with her day. That's the part that gets me every time. She didn't make a speech. She didn't warn my father. She just wrote down the truth clearly and trusted that if the truth ever needed to be found, someone would look for it. I think about that when I consider what my father did and what he didn't do. He had every opportunity to be honest. When my grandmother set up the account, when she died, when I started building toward something real, he could have said, that money is yours, I won't touch it. He knew what she intended. He knew because she told him, probably more than once, in that direct way she had. He made a choice anyway. And I think he made it because he had spent decades believing that his judgment about what the family needed outweighed anyone else's wishes, including his own mother's. That's not a small character flaw. That's a fracture that runs all the way down. And the hard thing I've had to sit with is that it didn't start with my money. It probably started long before I was old enough to notice. What I learned from all of it, the part I carry with me into the office every morning, is that integrity isn't something you perform when people are watching. It's something you practice when no one is. My grandmother practiced it alone in her kitchen, writing a letter to a bank manager who would likely never read it, because doing the right thing was more important to her than whether anyone would ever notice. That's the standard I want to hold myself to. I also learned that intelligence without honesty is just a more sophisticated way of causing harm. My father is a smart man. He found the loophole. He moved quickly, covered his tracks, brought in attorneys, filed counter motions. All of that took real strategic thinking. And every bit of it was in service of something that was wrong from the first dollar he moved. Cleverness spent that way isn't something to admire. It's something to grieve. And then there's the question of what you do when everything falls apart anyway. When the account is drained and your job is at risk and the certified letters are stacking up on your kitchen counter. I didn't have a backup plan. I had cereal for dinner and a photograph on my phone and a slowly emptying checking account. What kept me going wasn't certainty that I would win. It was just the refusal to let the version of events my father had written become the permanent one. That refusal is something. It might be the most important thing. Hendrik's Valuation Group. I chose that name on purpose. It's a reminder every single day that one careful woman with a pen and a filing system built something that outlasted every attempt to take it apart. I hope I'm that careful. I'm trying to be.